Hello, everyone, and welcome to One Civil Law. For today's story, we turn our attention once again to Karen Reed, and we pick up with filings that happened on the 7th that we haven't had a chance to respond to, and now seems like a good chance to respond to that. So that's what we're going to do. So let's go ahead and get started with that. We begin with the affidavit of the Special Prosecutor Hank Brennan to correct the record. And this apparently relates to misstatements he made accusing the defense of ethical violations. And for me, this was probably the most infuriating document I saw that was filed, because ethics violations are something that every attorney really should take very seriously because it's in our profession. And when another attorney violates their ethics, that's a big deal. And also accusing another attorney of ethics violations is also a big deal. So you don't make accusations against another lawyer without cause. It's actually unethical to do so. It's unethical to bring the profession into disrepute. So you can't just go around and accuse an attorney of ethics violations. You have to have good cause. And if you make representations in court or out of court, for that matter, either way, if you make representations that another attorney is violating their ethics, you better be basing that on information that you have. And that information better be correct. And you better double check your information, because if it's not correct, then you've violated the ethics yourself by making the accusation. And so this really sort of irritated me the most of anything, to be honest, because this is not the first time, incidentally, we've seen Brennan make these misstatements, let's call them, in court, where he, first of all, he said, "Oh, I got this from the government." It's like, no, actually, I got it from the defense. It's like, oh, that was a pretty big deal. Like, he's basically accusing the defense of hiding things by saying, "I only got this from the government, not from the defense like I was supposed to." And then he's like, "Oh, no, actually, I got it from the defense." Well, then they did exactly what they were supposed to if you got it from the defense, right? They didn't hide anything. They gave it to you. So your entire basis of your ethics complaint doesn't make any sense. And then he's like, oh, the defense lawyers have been making statements outside of court that have been prejudiced the case, except they weren't made outside of court. They're in a court. And again, it's like this. It's like the same thing. And how many misstatements do you really think you can get away with, man? I guess with Judge Bev, infinitely many. But my irritation as a judge would be very, very high, because like you don't do that. And I'd be considering an order to show cause why I shouldn't be whacking you around for basically recklessly accusing another attorney of ethics violations when it is an ethics violation. And that seems deeply problematic. So anyways, here was an affidavit to correct the record. My name is Hank Brennan. I've been appointed the special prosecutor assigned as lead counsel for the case of Commonwealth versus Karen Reed. In oral argument, I provided a number of examples of extrajudicial statements, which is statements outside of courtroom. That's what it means, extrajudicial, that have been made by defense counsel, as well as examples of in-court statements made relative to a now closed federal investigation and the potential impact such statements may have on the jury pool. One of the examples I cited to support commentary about the now closed investigation was a statement made by Attorney Atty. I inadvertently and mistakenly characterized one of the statements as extrajudicial. The statement by Mr. Atty was not extrajudicial. It was a statement made during a Zoom court hearing in the Reed case. Yeah, my irritation level would be pretty high as a judge. That's a pretty big boo-boo. That's a pretty big boo-boo. My irritation level will be pretty high. It's like, if you're going to accuse another attorney of ethics violations, you better make sure that the facts that you're relying on are correct with proper due diligence. And this does not seem like those are those things. So my irritation level would be really, really high. I'd be looking for the whacking stick right about now as the judge. Not for least of reasons, of course. As I mentioned, it's not the first time, right? This is at least the second time this has happened. The first time I might let it go. The second time, I'm looking for the whacking stick. I don't think Judge Bev is looking for the whacking stick, though. But it would irritate the shit out of me. These statements were aired as part of a segment by Court TV entitled Karen Reed's Attorney Talks Federal Investigation with Court TV. The segment included in the story regarding the case can be found at this URL. The 4121 segment video includes a Court TV's anchor story on the case, witness interviews, and includes some clips from a court hearing coverage, including a Zoom court hearing, which should have been probably readily apparent that it was a Zoom court hearing. You know, as opposed to them being made extrajudicially. So that's kind of a big difference. The quote from Attorney Yannetti was a statement made from Mr. Yannetti made during the Zoom court proceeding in the Reed case. I mistakenly stated that Attorney Yannetti's statement was extrajudicial. My mistake was unintentional and regrettable. Not for the first time. Not for the first time. Every attorney makes mistakes. We're all human. But accusing another attorney of ethics violations, to my mind, is a fairly big deal. And so you want to make sure that you're basing it on something that's real and you have a good faith basis for believing that's a violation of the rule. So, you know, do your due diligence. And if you make a mistake like that, I'm going to hold it against you because it's kind of a big deal. Probably not to Bev, but it should be. All right. And then like this entire thing with him making this misstatement, let's call it, was made as part of a basis for a gag order request, which then gets granted by the court. So the court doesn't seem to care because the court, apparently based on the timeline, did have this prior to them making the decision, although whether they saw it or not is a whole nother thing, but they did see it, or it was on the docket at least, prior to the court making this decision. And then they decided to grant the gag order anyway, despite the fact that the basis for the gag order was basically not true. So it doesn't really make any sense, but that's okay. We're doing it in Bev's world. So the motion to impose sanctions was denied. The Commonwealth's motion to prohibit extrajudicial statements of counsel is allowed, even though the statements we complained about were not extrajudicial. It's further ordered that none of the lawyers appearing in this case shall release or authorize the release of information about this proceeding that a reasonable person would expect to be disseminated by any means of public communication if the lawyer knows or reasonably should know that will have a substantially likelihood of material prejudicing potential jurors or witness in the case. So not only am I not allowed to make extrajudicial statements now, I'm also not allowed, presumably, to make statements even in court, because that would be in public, if they might prejudice the case. Which is odd, right? I mean, that's not normally how that rule works, right? I mean, everything you're saying in court pretty much is designed in some sense to create your side to be more likely to win or the other side to be more likely to win, depending on who's making the argument. So in some sense, every argument is designed to prejudice in so much as it's designed to make it more likely or less likely for you to win. That's part of the job. That's part of the job. But now I'm not even allowed to make statements in court, apparently, if they'll be disseminated to the public, because it might prejudice the case, even though I'm making them in court. So that's pretty weird. So now I have to kind of do things, you know, under seal, which is, you know, a little weird and annoying. None of the lawyers appearing in this case shall release or authorize the release of information lawyer knows or reasonably should know is likely to be inadmissible as evidence in trial. That's a whole nother thing. Like, now I have to anticipate what your ruling would be on a motion to exclude evidence. That's putting me in a very weird position as a lawyer. It's like I have to figure out whether or not it would be inadmissible or not. And I have to make that determination potentially against the interests of my clients. right? So I might think that a piece of information is more likely to be excluded at trial or less likely. But if I have a viable argument for why it should be admissible, then part of my duty as zealous representative of you is to make the argument, assuming it's otherwise in the strategic and tactical interest of the client. So assuming it's in my client's strategic and tactical interests, and assuming that it is non-frivolous, then it is my duty to make the argument, even if I expect to lose the argument, because I need to advocate zealously, and that's exactly what that means. Taking into consideration what is in my client's overall interests. So it might not necessarily be in my interest to make an argument because I might be losing something somewhere else. So that's possible. But assuming I'm not, it's my duty to make the argument. And now you're having me second guess myself because I have to guess, well, first of all, how would I know it should be inadmissible? That's a whole other thing. That's pretty rare. Or should reasonably know. So now I have to second guess myself in what arguments I make, which is a really weird position to be in. That's a really weird position. None of the lawyers appearing in this case shall release or authorize the release of protected information in this case, including information subjected to a protected order or information is protected under the rules of criminal procedure. I'm not sure why you need to tell me that, incidentally, because it was already under a protective order or protected under the rules. So I'm not sure why you need to tell me just to follow the rules. But okay, I guess. Lawyers appearing in this case shall remain subject to all relevant provisions of the Massachusetts rules. Again, why are you telling me this? I already knew this. Why are you telling me this? I feel like I'm being talked down to right now. But okay, that's exciting. All right. Then we have this, which we discussed a little bit during our last stream. The decision on the order to exclude the testimony of the witness, James Crosby, PhD. James Crosby is a dog behavior expert. He knows how dogs are trained. That's what he does. And he'd like to testify as to whether or not this bite came from a dog. It's like, okay, I have follow-up questions on that. It's like, I'm not sure that being a dog behavior expert makes you particularly qualified to determine whether or not this bite mark comes from a dog or not. I don't think you need to be an MD, and we'll get to that in a second, but I'm not sure dog behaviorist necessarily gives you that information. But Judge Bev disagrees for some reason. But even more to the point, Judge Bev had previously announced, or previously seemed to announce, or the defense at least seemed to announce, that if you wanted to testify as to the medical cause of an injury, which I'm not even 100% sure what that means, to be the medical cause of an injury. I don't really know. I don't know that doctors necessarily determine that, but maybe a coroner does, but your average doctor probably doesn't. But what is the medical cause of injury? But if you want to testify as the medical cause, you need to have an MD. Well, this guy doesn't have an MD. He has a PhD, which is definitely not an MD or a DO. It's none of those things. He's not even a doctor of veterinary science, which maybe that's an MD enough, right? Maybe a doctor of veterinary science. He's not even that. He's something else. He's not a veterinarian. He's something else. He's a dog behavior expert. It's like, okay, so we want this guy to be able to testify that this bite mark definitely didn't come from a dog. I have questions relating to this. The judge apparently is satisfied. After hearing and reviewing the pleadings, the court finds the Commonwealth has satisfied the foundational requirements of Daubert. The evidence will assist the jury. Dr. Crosby is an expert in dog bite wounds. Deeply questionable. There's an appropriate basis for his opinion in the record, and his proposed testimony, principles, and methods employed are reliable. Also extremely questionable, because his report didn't seem to have any real methods, and his own master's thesis seemed to contradict him on this point. Defense objection goes to the weight of evidence, not admissibility. Therefore, the motion to exclude is denied. So I have questions on this on its own terms. I don't think that he's necessarily an expert in dog bite wounds. I find that questionable. Even more questionable is whether or not his proposed testimony principles and methods employed are reliable, because it didn't really seem to have any of those that really seemed to merit the weight. So it seems questionable. And then again, it's like, also, what is the rule exactly? Because she said, because this guy wants to testify that these wounds, which, are which might have killed, John O'Keefe, are not dog bite wounds. She seemed to say earlier that you needed to be an MD to do that. Obviously, this guy isn't an MD. So the question is, can the ARCA guys, or for that matter, anyone else who's not an MD, now testify as to what the source of these wounds are? And the answer to that question is, I don't know, because she doesn't tell me the rule. Right? Now, I will say this much. If the judge had just simply said, okay, I made a mistake in the previous trial. I said you had to be an MD, but that was wrong. I made a mistake. So I'm going to correct that. I would have been fine. Judges make mistakes. I make mistakes. We're all human, right? And judges can and certainly should, in fact, even must correct themselves when they make a legal mistake. So if she had said, oh, geez, I don't know what I was thinking during that first trial, that was a really dumb thing for me to say. Of course, there's no requirement that you're an MD in Massachusetts. I didn't think that made any sense anyway. Of course, there's no such requirement. I don't know why I should impose it anyway. So I'm going to take that back. You don't need to be an MD anymore. And therefore, that's part of my decision making. I'd be less grumpy. But she didn't say any of those things. She didn't say, I made a mistake. You don't need to be an MD. What a silly thing for me to do. So this guy's fine. And also, by the way, you don't need to be an MD. That was a silly thing for me to say. She doesn't tell me that. She's just like, this guy's good. And I'm like, okay, but what's the rule? And she doesn't really tell me other than to say Daubert. It's like, okay, well, if Daubert is the rule, which, fair enough. If this guy's qualified, which again, questionable under Daubert at best, but if this guy's questionable, surely the ARCA guys are qualified. And if they're not qualified, why not? Why aren't they qualified? And what is the rationale for that? So she doesn't really give me any of that information. So it makes it difficult for me to say, well, maybe why should the ARCA guys be allowed to testify? And if not, why not? What is the rationale for that? And she doesn't give me anything. She just gives me the conclusion. And the conclusion frustrates me. It frustrates me as a lawyer because I want to know what the rule is. I want to know what the rule is so that your decisions are more predictable. So it's like, I don't know what I'm supposed to do with this if I'm the defense. I don't know what I'm supposed to do. All right, then that page that we just skipped is page 2 of this document because it's out of order. So we'll obviously start with page 1. This is supplemental exhibits in support of defendant Karen Reed's motion to dismiss. We're still giving exhibits relating to this thing. That's fun. Exhibit 1, corrected version of inverted interior Salaport garage video, accurately reflecting right rear taillight as being the right rear taillight. Counsel specifically directs the court's attention to 115 to 149, during which time Trooper Proctor approaches and has unfettered access to the right rear taillight of Miss Reed's SUV. Surveillance footage also shows an unidentified individual apparate and then disappear from the frame near the rear taillights. That's not sketchy in any way, right? It's like, and the defense pointed this out earlier. It's like we have people just appearing randomly on video. They don't walk into frame. They just randomly appear. That's in no way sketchy. That's in no way sketchy. Which gets me back to authentication among other problems. The evidentiary problems in this case are legendary. This has got to be, I think, the worst case for evidentiary problems I think I've ever seen ever. I've seen worse conduct from the government in just like not turning over documents before. We've seen that. We've seen court cases where, oh, by the way, I had this file box in my basement for 20 years that I never gave over to the defense that totally proves the guy's innocent. Sorry about that. We've seen that kind of case right before. So we've seen, I just deliberately withheld the evidence for 20 years as the guy's rotting in jail. My bad. So we've seen that, but just for like the evidence that's actually turned over, not putting aside what evidence they might not be turning over, but the evidence that's been turned over has been the most shaky evidence by far I think I've ever seen in any case. I've never seen evidence that's like this before. That's this bad. With apparating people and missing pieces of videotape and, solo cups and missing logs and evidence floating around in someone's trunk for a month and so forth and so lab issues and it just goes on and on and on and on. It's a lot, man. It's a lot. And, I'm willing to extend grace to the government too. Again, we're people. We're all people. The government is people too. And people make mistakes. So I'm willing to extend you some latitude. It's like, okay, I'm willing to extend you some grace here. It's like something didn't go completely right. I understand. We're human beings. Things don't always go right all the time. But I'm like, geez, how many things exactly do you want me to give you grace for before I'm like, this is just system, this is a real problem? It's like, how many cards do you want me to pull out of this house of cards and be like, oh, the house is still standing? Right? It's like the evidentiary problems are so legendary in this case. I really just want to turn to the Commonwealth and laugh and be like, really? Really? This is the case you want to prosecute with these problems? Really? And then that's putting aside, and then of course, as a judge, or as a defense lawyer, in my mind, I'm just screaming, authentication, 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 right? How do we know this evidence is what it purports to be? How do we know it is what it purports to be? With missing logs, missing chain of evidence, right? Lab issues. So I'm just going to test one of the cups. I'm not going to tell you which one. Apparating people appearing on camera. I'm like, how do I get to authentication? How do I get to this is what it purports to be? I have serious authentication problems with much of the evidence in this case. Much of the evidence in this case, I have serious authentication problems. It's a lot. It's a lot. Photograph of the condition of the right rear taillight in Miss Reed's SUV in the Canton Sallyport garage on February the 1st, 2022, after Trooper Proctor and others at the Canton Police Department had access to the vehicle. Taillight appears fully damaged, not cracked. That evidence is in no way helpful to anything. Yeah, I don't think that means what you think it means, Commonwealth. If it's after Trooper Proctor had access to it, the defense's kind of theory, or one of their theories at least, is Trooper Proctor might have taken advantage of his access and broken up the taillight and then taken those pieces to 34 Fairview. So it's like we have a picture after Trooper Proctor that shows the taillight damaged. It's like, yeah, that doesn't really help me. If you had a photograph of it before Trooper Proctor had access, that would be a lot more helpful. Do you have one of those? That'd be great, but not so much. Photograph of a reconstruction of the taillight with pieces of plastic recovered from 34 Fairview. Even after full reconstruction of the taillight, it appears cracked and missing a piece. Consistent with Sergeant Barrow's testimony regarding his observation of the right rear taillight of the Lexus SUV at Miss Reed's parent house. Yeah, I mean, he said it was missing a piece, like a small piece, not like 34 pieces, not gone, not disappeared. So, yeah, you weren't able to find a piece of the taillight. Okay. I mean, that's consistent with the defense's argument too. They argue that it was cracked or broken when she hit that car when she was backing out of the driveway. And it's like, okay, we think the piece was missing then. And we're like, okay, we were never able to find that piece. Okay. Kind of consistent with what the defense is arguing. Do you have pictures of it when it was being towed? Why didn't the tow truck driver take pictures of the car when it was being towed? Isn't that pretty standard practice for tow truck drivers to document the car to see what it looks like before they tow it, to like avoid claims of, liability relating to damage? Isn't that pretty standard practice, especially these days with everyone having a smartphone? No one took pictures of this car before it was towed. None of the police, no one broke out their smartphone and took some pictures. Really? Including the tow truck driver? No one? Really? So this seems odd. Do you have any of those pictures? That'd be really helpful. That'd be great. Do you have any of those? That'd be nice. But they don't seem to have any of those for some reason. Which, to me seems a little sus. Seems a little sus. Okay. Exhibit 4. Photograph of 47 pieces of taillight material recovered from 34 Fairview. At different times, I'd like to take note. Right? How many pieces were found at 34 Fairview? Well, when? When is an operative question that I didn't think I'd have to answer. When? Right? Oh, it's like, well, initially, during the initial search, it was 0. And then I think it was the search team. I think that they found 4, I think. And then I think a lot of pieces were found later when someone just happened to be driving by, just randomly, just driving by, just happened to be driving that way. And I decided to go check the scene and found a lot more pieces and so forth and so on. So, yeah, when were those pieces found is an interesting and operative question with respect to the thing. Yeah. Screenshots establishing Commonwealth Exhibit 2, which purports to show interior Sallyport back wall camera, also inverted, has a different color chyron from the inverted video produced the defense. Yeah, that's a problem. This discrepancy suggests manipulation and further underscores the prejudice to misread by the Commonwealth's destruction of the original files. Yeah, that's a little weird. That's a little weird. So we have a January 29th, 2022 video, and we have an April 4th, 2024 video, both of which are inverted, but they have different colors of text on them. They have different colors of their timestamp. That's kind of weird, right? It's the exact same camera, inverted. Okay, inverted I sort of understand. Some cameras will do inverted. I've had that problem before with inverted cameras. I understand that. But why is it different text that's been showing the timestamp? How did that happen? And I'm sure the Commonwealth is going to come up with a really good reason why they're different. But, it seems sus. And again, if it was like the only thing, then my tolerance for hand waving it away would be a lot greater. I'd come up with more interesting answers. It's like I can come up with some interesting answers off the top of my head, but I'm less inclined to come up with those interesting answers because of everything else. So if it was just the one thing, it'd be like, oh yeah, we We had a different recording software. It's the same camera, but we recorded it different. We had a different DVR, and the DVR is the thing that imposes the timestamp, and that's why it's a different color. I'd be like, oh, okay, that makes sense. But my tolerance for creative interpretations is diminished because of so many other things, right? So many other things. Jojo Miru for 10 Canadian dollars says the biggest piece, the bottom right with the flaps ridge, was clearly on the car at the Sally Port and then teleported to the crime scene. I'm not saying you're wrong, man. I'm not saying you're wrong. So there are many, many questions relating to much of this. Okay. And then finally, we have this motion to deny Pro Hoc by Mark Betterow. Mark Betterow is an attorney for Turtle Boy, a case that I really haven't dived into. I watched parts of the hearing, most recent hearing. I wasn't watching it full time, but I was watching pieces of it as I was sort of doing other things, just, to wet my whistle a little bit. And I couldn't help noticing at one of the points I tuned in that with respect to Turtle Boy, the prosecutor was suddenly talking about torts. He's like, Turtle Boy can be sued for defamation. And I'm like, did we turn into civil court when I wasn't paying attention? I thought you were the prosecutor, and I thought this was a criminal case. And now suddenly you're talking to me about civil defamation. What are we, are you confused? Did you forget where the civil court is located? I mean, I could give you directions if you lost your way. But it's like, okay, I ultimately take no position at this time, incidentally, on whether or not Turtle Boy is guilty or not with respect to the witness intimidation charges. I haven't looked enough into it to have a firm opinion. But I did find us suddenly talking about defamation and civil law to be a little out of place in a criminal trial. So while I take no ultimate position at this time on the issue of Turtle Boy's potential liability, civilly or criminally for that matter, I found it to be a little out of place. Pressing on, Mark Betterow is one of the attorneys for Turtle Boy, and he would like to also be one of the attorneys for Karen Reed. Okay. The judge is not really having it. After reviewing the pleadings, the defendant's supplemental motion for admission pro hoc vice of attorney Mark Betterow is denied. Okay. The affirmation submitted in support of the motion is insufficient on its face. Why, she doesn't say, by the way. She doesn't say why it's insufficient on its face. So again, that's conclusory. Now, I'm not saying that you're wrong, Judge, but I am saying that you're not giving me the reason. You just went straight to the conclusion. The affirmation submitted in support of the motion is insufficient. Okay, why is it insufficient? Would you like to tell me why it's insufficient? Educate us on why it's insufficient. Tell us why the attorneys did not do a good job on it. Please tell us how they failed. I mean, it's a great opportunity to make the defense look like shit, right? I mean, why not, right? Their lawyers don't know what they're doing, man. Their lawyers don't know what they're doing. Let me tell you all the ways that their thing is insufficient on its face, so we can all point and laugh at them. But she didn't do that. She didn't tell me why. She's just like, it's insufficient. All right, I guess I don't know what I'm supposed to do with that, but but noted. In addition, the purported concurrent representation involves a conflict of interest that's not waivable under the Massachusetts rules of professional responsibility. See, not even for example, just see Massachusetts rule of professional responsibility 1.7 A and B. See also comment 22 and 23. Okay. We will take a look at that in just a second. Spoiler alert, Rule 1.7 deals with waivable conflicts of interest, not unwaivable. There are such things as unwaivable conflicts of interest. That is a thing. Of course, what those are depend a little bit on your state. Every state has their own rules. Every state basically follows the model rules of the ABA, but they make significant modifications along the way. I guess how significant they are is debatable, but in any event, they make modifications along the way. So there is such a thing as an unwaivable conflict of interest. That is a thing. But the section she cites only deals with waivable conflict of interest, not unwaivable. So she's like, it's unwaivable under this rule. And I'm like, no, it's not. Not under that rule. Maybe some other rule, but not that one. So, okay, we'll get to that in a second. One such conflict is specifically outlined in the motion in paragraph 8 of the motion, where Mr. Betterow, apparently speaking through Mr. Yannetti, promises to restrict his use of certain information. Okay. The clear inference of that promise is that Mr. Betterow would not use protected information gained in the representation of one client for purposes of representation of another client. Which, okay. I mean, attorneys keep secrets. It's one of the things we do. And it is completely possible for me to gain information from one client that would really benefit another client. And I can't tell them that because I have secrecy obligations. It's like, okay, we get that. We get that. So it's like, I can do this, to some degree, I do it all the time. It's like, it's fine. It should be fine. We can work with this. But she's not in for that for some reason. He thus proposes to ignore information known to him through his representation of one client, even where the information might benefit a second client. Yeah. The court cannot permit such conflicted representation and declines to add to the defense team that currently numbers at least 4 lawyers, 3 by admission pro hoc vice. I'm not sure why the 3 being admitted by pro hoc vice is relevant to this or not. I'm not sure why that changes the analysis. If all 4 were not pro hoc vice, I'm not really sure what the difference in this context is between 4 lawyers licensed in Massachusetts versus 1 lawyer in Massachusetts and 3 that are pro hoc. So I don't really know what the difference between those two things is with relation to the rule, but okay. So therefore denied. All right. So she cites rule 1.7 A and B and comment 22 and 23. So let's read that and discuss. Here is rule 1.7. Okay. Here is the rule. Again, your mileage will vary slightly depending on your state. This is Massachusetts version of the rule. So that's what we're going to discuss right now. Okay, great. Except as provided in paragraph B, a lawyer shall not, that's a requirement, right? You can't, right? Shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if the representation of one client will be directly adverse to the other client, or there's a significant risk the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by personal interest of the lawyer. All right, so basically don't represent somebody if you have 2 clients and their interests are opposed, or there's a risk that my representation of you will be limited due to my duty. So either we're fighting each other or I have information that I can't use and that will harm you materially. All right, that's what that rule sort of contemplates. All right, then part B. All right, notwithstanding the existence of a concurrent conflict of interest under paragraph A lawyer may represent a client if, okay? So again, we have to distinguish between unwaivable conflicts of interest and waivable conflicts of interest, right? And at least this rule, at least with respect to B, says, okay, you can do it if these things are true, right? That's what it says. You can do it if these things are true. All right, great. So what things have to be true in order for me to do this? All right, 1, The lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. Well, that sounds good. I mean, that's part of my duties anyway, zealous representation by another name. So one of my duties as a lawyer is to present zealous representation to my client, which means advocating for their interest within the bounds of law in a non-frivolous way. Also, in so much as it doesn't harm their overall strategic or tactical considerations. So yeah, I have to provide zealous representation to my client. And so one of the things I need to believe is that I can zealously represent both clients at the same time. Okay, fair enough. I'm going to assume Mr. Betterow believes that because he's asking for the pro hoc. And I'm even going to go so far as to assume it's reasonable for him to believe that because, why not assume that he's being reasonable unless you can prove he's being unreasonable? He's a lawyer. It's not that lawyers can't be unreasonable, but, I'm going to assume that he's probably reasonable. So let's press on to number 2. Number 2, the representation is not prohibited by law. Well, if it were prohibited by law, that would be really easy. I mean, Judge Bev could simply cite whatever law it is and say, you're not allowed to do this because of this reason. And we'd be like, oh, okay. Right. It's like, oh, it's not, you can't do it because of some other law somewhere, some other rule. It's like, oh, okay. But she didn't cite any of those things. So I'm going to assume it doesn't exist because she doesn't tell me it does. So I'm guessing 2 is not the thing. Or is 3 the thing? The representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or another proceeding before the same tribunal. Okay, a classic example of number 3 would be in a criminal case in which there are 2 co-defendants. Okay? And I'm a lawyer and I'm representing both. Can I do that as a lawyer? Typically, yes. I can represent multiple defendants in the same criminal trial. I can typically do that. Now, what if one of the defendants comes to me and says, okay, I'd like to start cooperating with the state. I'd like to turn state's evidence, and I'd like to get a deal from the government. It's like, okay, now let's assume I talk to my client in a completely neutral way about the pros and cons of doing that and fully inform them in a completely neutral way. Let's assume I'm able to do that much. All right. So I give full information to my client, and my client's like, even after, being fully informed in a completely neutral way, I still want to do this thing. And I'm like, okay. I mean, I have to respect the wishes of my client. Now I have a problem. Because let's suppose one of my other clients is like, I ain't taking a deal ever. They'll have to drag me to prison. You'll never catch me alive, coppers, right? Now I have a problem because I have a client who now wants to testify against the other client. Well, that sounds like that's going to be an issue for me because that sounds pretty adverse. So I can't represent both at the same time. So I've got to, at a minimum, drop one or the other, perhaps both. But I've got to, at a minimum, drop one or the other, find the other guy, a lawyer, and then that lawyer would then negotiate with the prosecutor. I can't even go so far as to negotiate at that point with the prosecutor, right? I can't even do that much. It's like you need to have a separate lawyer to do that. I'll help you find one, but I gotta bail. That would be a classic example of that. Okay. All right. So in this situation that we're in, all right, do we have anything like that? Do we have an assertion of a claim by one client against another, represented by the lawyer in the same litigation or another proceeding before a tribunal? Do we have that? And I'm like, well, to the best of my knowledge, no. I'm not aware of any claim Karen Reed has against Turtle Boy or Turtle Boy has against Karen Reed. I'm not aware of that. So I don't know what that would be. And again, Judge Bev doesn't tell me it is. It's not like, oh, there's this conflict. She doesn't tell me what the conflict is. I'm not aware of one. She didn't tell me there's one. So it's like, okay, number 3 doesn't seem to really apply here. I don't understand. Yeah. Jules says, how do retainers work if you drop one before they get back? Well, that's going to be specified by the retention agreement. And typically, I'm going to be paid by the hour, especially in a criminal case, incidentally, because I can't take contingency. It's actually unethical in a criminal case. It's unethical for a lawyer to take contingency. So I'm either getting a flat fee, in which case I'm not exactly sure how that would work in that scenario. I don't know. I'd have to probably go peer the pages of the ethics rules to figure that one out. But if I'm getting paid by the hour, then it's easy enough. I just give you back any money I haven't expended. Right? So that's easy enough. You gave me $10,000. I've done $5,000 of work for you. I give you a $5,000 refund. No muss, no fuss. Easy peasy. So that's it. All right. And then 4, each affected client gives informed consent confirmed in writing. Again, I'm going to assume that happened, because otherwise she would just say there's no informed consent. That hasn't happened. So I'm going to assume that happened. So since it seems like none of these apply, or would it be a barrier, then that makes it waivable. And so it should be a waivable conflict of interest. All right. And then she cites comment 22 and 23. So let's see if comment 22 and 23 can provide any further illumination to us on our initial read. (21, 22). All right, here's 22. Consent to future conflict. 22. Whether a lawyer may properly request a client to waive conflicts that might arise in the future is subject to the test of paragraph B. The effectiveness of such waivers is generally determined by the extent to which the client reasonably understands the material risks the waiver entails. The more comprehensive the explanation of the type of future representations that might arise and the actual and reasonable foreseeable adverse consequences of those representations, the greater likelihood the client will have the requisite understanding. Thus, if a client agrees to consent to a particular type of conflict with which the client is already familiar, then the consent will ordinarily be effective with regards to that type of conflict. If the consent is general and open-ended, the consent ordinarily will be ineffective because it's not reasonably likely the consent will have understood the material risks involved. On the other hand, if the client is an experienced user of legal services involved and is reasonably informed regarding the risk a conflict may arise, such consent is more likely to be effective, particularly if, for example, the client is independently represented by other counsel in giving consent and the consent is limited to future conflicts unrelated to the subject of representation. In any case, advanced consent cannot be effective if the circumstances that materialize in the future are such as would make the conflict non-consentable under paragraph B. All right, that is a lot of verbiage. Let me make it simpler. Okay? Basically, this can be analyzed as a contract. And contracts sometimes have things that are unknown in the future. Okay? Things are going to happen in the future, and we're not sure what those things are going to be. Okay? And typically, how do you deal with that? Well, what you basically do is you try to give as much information in the contract as you can, giving the nature of the conflict or the nature of the unknown. The nature of the unknown is more the thing than the conflict, the nature of the unknown. So what you try to do is say, hey, look, there are some unknown factors here in play, and we don't know how it's going to pan out. And so here's some risks that apply, potentially to both sides, right? There are risks to your side, there are risks to your side, but like everyone knows what those risks are, and so everyone is reasonably informed and everyone therefore consents, right? Perhaps the stupidest example of which might just be any futures contract, right? Because any futures contract is an agreement to buy or sell, as the case may be, in the future at a fixed price, right? And so, well, what's going to happen to that price in the future? Well, we don't know because it's in the future. Who knows, right? So that's the whole point. The whole point of the futures contract is to fix in certain the unknown. And then it's like, oh, so then you can't turn around and be like, oh, the price went way up or the price went way down, right? The market collapsed or the market's gone to boom. It's gone to the moon, baby. It's gone to the moon, right? Either way, it's like, that was the whole point, was to fix the thing in place. So you're all taking that risk, but we all understand that risk. So that's the deal. And, let's all move on with our lives. And someone might be sad. Someone might be very sad, but that was part of the deal. And you knew that, so sucks to be you. Okay? That's kind of what they're talking about. And essentially, it's exactly the same in this context too. So basically, what my job here as a lawyer is to try to tell you, with as much information as I can, what the conflict is or what the conflict is likely to be. And here, that conflict seems to be a little bit more known than some other examples are possible. It's like the conflict would be, I'm going to get information from Karen Reed's defense that I'm not going to be able to use in your defense unless I can get that information separately and independently. If I can get the information independently, then fine, right? So if I get the information through normal discovery or I get the information through some other means, then great. But I can't use because I got it from Karen Reed. And so this feels like a more on the side of this is a known risk, right? This is more of a known risk. It's not just, oh, I'm going to represent someone in the future. I'm going to represent someone at some time in some sort of way, which, by the way, every lawyer, including myself, has in their retention agreements because we're not idiots, right? Because we're not idiots. But, we try to cover ourselves as much as we can. We're lawyers. So like every lawyer has the generic, this could be a conflict in the future because we're not idiots. But in this example, it feels a little bit more real than that because the conflict is more known. So I don't know how this rule applies because it feels like we're more on this is a known risk. This is a known unknown, as Rumsfeld might say. This is a known unknown as opposed to an unknown unknown. And so following the Rumsfeld rule, this feels like something that should be more well understood. So I'm not sure how this rule applies either, but that's okay. All right. And then we get up to conflicts in litigation, rule number 23. All right. Paragraph B3 prohibits representation of opposing parties in litigation, regardless of the client's consent. I can't be a lawyer for both sides at the same time. Not allowed to do that. You can be a mediator for both sides at the same time, but that's a separate rule. But I can't represent both sides in a lawsuit at the same time. I have to pick a side. Although it would be hella fun. And I've done it in moot proceedings, which is so much fun. It's so much fun arguing against yourself. It really makes you think. It's great. But you can't do it for real, which is very disappointing. On the other hand, simultaneously representation of parties whose interests in litigation may conflict, such as co-plaintiffs or co-defendant, is governed by paragraph A2. A conflict may exist by reason of substantial discrepancy in the party's testimony, incompatibility of positions in relating to an opposing party, like I'd like to plead, I don't want to plead, that kind of thing. I'd like to turn state's evidence, I really don't, that kind of thing. Or the fact that there are substantially different possibilities of settlement of the claims or liabilities in question. So if the positions are distinct enough, it might be a problem. Such conflicts can arise in criminal cases as well as civil. The potential for conflict in representing multiple defendants in a criminal case is so grave that ordinarily a lawyer should decline to represent more than one co-defendant or more than one person under investigation by law enforcement authorities for the same transaction or series of transactions, which is the criminal transaction is the set of crimes that are closely related in time and or purpose. And so they're the set of crimes that are closely related enough that they can be tried together in some level. And so like an example of which might be, I'm robbing a bank, and on my way out of the bank, you're driving by, and I hijack your car in order to escape from the police, right? So that might be an example of a criminal transaction, right? The grand theft auto, with the using the gun and stuff, is a separate crime from the bank robbery, right? They don't have anything to do with each other inherently, right? There's nothing about a bank robbery that requires me to steal a car, and there's nothing about stealing a car that requires me to do a bank robbery. So they're independent crimes. Nevertheless, they're part of the same criminal transaction because they're closely related in time and or purpose. I stole the car in order to flee the scene of the bank robbery. I stole the car for the purpose of effecting my escape from the bank robbery. So they're closely related in time or purpose. So that's what a transaction is in this context. Right? Fun. And then of course, there can be multiple transactions for multiple different sets of crimes that have nothing to do with each other, but we're prosecuting all at the same time because, I don't know, convenience or something. So I'm prosecuting you on the one hand for the grand theft bank robbery thing, and completely independent of that, as a separate transaction, I'm also prosecuting you for, I don't know, let's see, what else am I prosecuting you for today? Let's say I'm prosecuting you for littering and an overdue library book, which is the thing that you littered. You were walking down the street and you had an overdue library book in your hand and you didn't want to be caught with it, so you threw it away into the forest. So I've got you for littering and I've got you for an overdue library book, plus the armed carjacking bank murder. So those might be two separate, independent criminal transactions. Okay, great. So moving on with that. So it is so grave that ordinarily a lawyer should decline to represent more than one co-defendant or more than one person under investigation by law enforcement for the same transaction or series of transactions, including any grand jury. So it's not prohibited, but it's somewhat discouraged because it's very easy to see in advance how these interests are going to become disparate, right? Because it's very easy to see, one criminal defendant's going to want to, turn state's evidence and the other one's not, or whatever, right? So it's like it's not strictly prohibited, but it's discouraged because it's really, really easy to see in advance how this is going to go wrong. So you probably shouldn't do it in the first place, but you technically can, but you probably shouldn't. On the other hand, common representation of persons having similar interest in civil litigation is proper if the requirements of paragraph B are met. And that is the end of Rule 23. So that also doesn't seem to apply to this situation. So neither the rule nor the comments to the rule seem to apply in this situation. So that's annoying. That's annoying. Now, I suppose to Judge Bev's limited credit, it is not unheard of for a judge to step in to protect a defendant from themselves. So it is not unheard of, and properly so in many situations, to be quite honest. It is not unheard of for a judge to be like, yeah, I know you want to do this, and I know you've consented, and I know your lawyer says okay, and I know all those things, but just still no, I'm just not going to let you because I need to save you from yourself. So it's not unheard of, but that's not what the judge said. She didn't say like, oh, I'm just doing it because in the exercise of my discretion, notwithstanding the fact that the rule doesn't apply, in my discretion, I still feel like it's bad mojo. She could have done that, but she didn't do that. She tried to ground her reasoning, as such as it was, in the rule. And the motion being insufficient on its face, whatever that means, not bad vibes. If she had grounded it on bad vibes, I'm like, okay, I understand that. You can do that, and sometimes appropriately. But that's not what she said. And I can only take her based on what she said. So, all those things. So there's that. So, yeah, that's sort of the end of my analysis on those documents. And my continuing irritation with Judge Bev continues for many reasons that we have highlighted. Let's see if there were any other super chats that came in. I didn't think I saw any, but let's see if there were anyone else that came in. Jojo, we read. Karen Cars 10 for $5 said, "Hey, Aunt Bev, you're biased because you're biased." And Snacks has been a member for 16 months. Thank you very much for your super chats, as always. In terms of whether or not they can appeal, probably not. I don't think the denial of pro hoc is appealable. The denial of the motion to dismiss is not appealable. And so probably not on any of these things. And the gag order is not really appealable. So I don't really think any of this is appealable. So I think we're kind of stuck with that. And that's where we're sitting. Do you guys... Oh, there were supposed to be documents that were filed today by the court. Did those get filed, by the way, in the last hour since I've been talking? I presume no, since no one's been yelling at me that the court dropped anything in the last hour. And if not, I'll take any questions that you do have. Can they report Bev for judicial misconduct? I'm not sure you could really find it, to be honest. Yeah. I'm not sure you can really find it. Judges are given a lot of latitude. I think you'd have a difficult time trying to show that she's... Yeah, it's challenging. And even trying to prove bias is really, really tough because you can't really just show it just based on results. You can't show bias just based on the mere fact that the judge is always doing something or always doing something else, because that may not be biased, right? And I've said this before and I'll say it again. It's like, just because the judge is always ruling for the prosecution or just because the judge is always ruling for the defense does not inherently mean the judge is biased, because maybe that's just the right answer, right? If the baseball umpire says it's a strike every single time, maybe it is a strike every single time, right? It would just be a perfect game. Those are rare, but they happen, right? So you can't just simply say that because they're ruling 100% this way or 100% this way, they're biased. So proving bias is actually really, really tricky. And so I don't know that you can get there on judicial misconduct. And even on an appeal, trying to show bias is very difficult because judges get a lot of latitude in their courtroom. And so it's very problematic. I'm not saying it's not worth a try. I'm saying it's very difficult. Yeah, her commentary and behavior infers bias. Yeah, I mean, she's never really said anything explicit, or in a way that reveals her bias. She's never really said, anything that would... It would be very challenging. Don't need all strikes for a perfect game, just no hits and no walks. Noted. She deserves reprimand? Yeah, maybe, but getting there is difficult. Yeah, maybe you can flip a coin 1,000 times in a row and it comes up head 1,000 times. Yeah, that kind of thing. Yeah, right? Yeah, so it's very challenging. How was the pot roast? It turned out okay. Not my favorite dish, but it turned out okay. It didn't turn out too salty. It turned out okay. Oh, by the way, I weighed 349.9 today. Victory. I was so excited. I was hoping this morning I would trip that barrier, and the scale was oscillating. And the scale was oscillating a little bit before it landed on 349.9. Yes. Small victories, man. Small victories. I'm happy. I'm happy. Check Discord. Oh. Media rules for Karen Reed's second trial just released from court. Oh, okay, that's cool. We got one more thing. Excellent. We can do one more thing. One more thing. One more thing. All right, let's save this. How do I? Okay, let me do it this way. Yeah. Oh, hold on one second. Give me a second. I'm working here. Give me a second. Make sure I'm eating enough protein. I'm definitely eating enough protein. That's definitely not the problem. I mean, basically lots of protein. Well, I mean, a lot less, but I'm eating protein. Chicken breast and beef. Yeah, I don't think protein is my problem. Ugh, am I timed out? Nope, not really. I can see your chat, so I'm going to go with no. You're not timed out. All right. All right. Here is this document that just dropped. Commonwealth of Massachusetts versus Karen Reed, order regarding media protocol and coverage. I'm going to take a deep breath. I haven't read this yet. Okay. The guarantee of a public trial grounded in the democratic values of public accountability and openness serves as a safeguard against attempts to employ our courts as instrument of persecution. I've got some bad news on that one as it relates to this trial. Today, a trial is made public through live broadcast through registered media members who are regularly engaged in reporting and publishing of news or information about public interest. While maximizing freedom must be allowed in the press carrying on this important function in a democratic society, its exercise must necessarily be subject to maintenance of absolute fairness in the judicial process. In order to ensure the safety and well-being of all trial participants, defendants' right to a fair trial by impartial jury, conformity with the rule, and dignity of the proceedings, the court enters the following order, which I don't have a copy of because I only have page 1. No problem. I will get the remainder of the thing. Give me a second, please. Wait, and you wait, and you wait, and you wait. And now Twitter's not loading. So we are all now being teased. We are all now being teased courtesy of Twitter. Twitter has failed us. Twitter has forsaken us. What's the answer? Well, there's an order relating to the media. I have no idea what it says. Lol. All pages are now on Discord. Excellent. All right. Thank you, Tony. Tony is our mod. He's our hero. I can be your hero, baby. I can wash away the pain. You are my everything. Deep breaths. Technology has failed me. Everything has failed me. It's okay. I will make it work. I know Discord. I know. I see it. I'm there. I'm working on making the margins pretty. Give me a second. I see it. I'm working on it. All right. Page 2. Media representatives, reporters, journalists, and anyone else claiming status as a journalist under Rule 119 shall be required to sign in every day in a manner prescribed by the clerk of court and shall show proof of registration with the Supreme Judicial Court Public Information Office. There shall be a designated seating area for the media. Any journalist registered with the Supreme Judicial Court under Rule 119 seeking access to broadcast or photographic or audio material for broadcast, streaming, or posting on the internet must coordinate their request and access through the designated media pool representative. That's pretty standard, right? Just one person doing the streaming thing, so that makes sense. Filming, streaming, photography, recording, transmission, or broadcast of any court proceeding shall occur only through pool arrangement. Typical. The court shall permit one stationary, mechanically silent television broadcast or streaming camera and one still photographic camera during trial. They don't want the camera to make noise. Fair enough. So no shutter noise, right? No shutter noise. Find a camera that doesn't have a shutter. No problem there. Or a mechanical shutter at least. All right. Pool cameras and cameras operators shall be in place prior to the start of session and shall not be dismantled while the court is in session. Okay. The camera operator and other members of the media pool shall not interrupt the court proceedings with technical problems. So if it goes wrong, that is your problem. You figure it out. Don't bother me. Fine. Filming, streaming, photography, recording, transmission, or broadcast of any kind shall not take place until the court is called into session when the judge enters the courtroom and takes the bench, and shall immediately cease during court recess and upon adjournment each day. Fine. So no more with the noise of the court as people are filtering in. Until the judge takes the bench, no broadcasting, no milling about, streaming. Okay, that's fine. Except as permitted in number 1, number 2, no person is permitted to film, photograph, record, and stream, transmit, or broadcast court proceedings at any time through photograph or electronic recording devices, including still or video cameras, cell phones, smartphones, tablets, laptops, audio recording or transmission devices, or any other electronic device, except as permitted in number 1, number 2. No person is permitted to use any electronic device with communication capabilities to submit updates to social media. So you're not allowed to live tweet from the courtroom anymore. So no live tweeting if you're in the courtroom, or I suppose no tweeting of any kind, or at least no updates to social media. So maybe you can submit stuff to in mainstream media, like you can submit press reports, but nothing to social media from the courtroom. Okay. In accordance with Rule 119, no person is permitted to record, transmit, or broadcast sidebar conferences before the judge and counsel, conferences between counsel and conferencees, between counsel and defendant at any time. Fair enough, right? I mean, don't broadcast, the lawyer speaking to each other or the lawyer speaking to their own defendant or the sidebar. You're not allowed to transmit that because that's, not to be broadcast. Fair enough. That's fair. The pool camera operator shall pause or disengage the audio component of the pool camera during sidebar. Okay. All microphones shall be shut off during sidebar. The pool camera operator shall not manipulate the camera's zoom and focus so as to reveal accidentally or otherwise documents of attorneys, the clerk of court or judge, or any other document not admissible or not published to the jury. I mean, it's kind of sad to some degree we have to say that out loud because we've seen camera operators do that. And when they do it, it's some bullshit. And so I have no problem with this because it's some bullshit, right? It's like, let me zoom in on the defendant as they're writing, on their pad. Let me zoom in on the document the defendant is holding and passing through with their defense lawyer. That's some pretty big bullshit, man. That's some pretty big bullshit. And so I'm like, I have no problem with that, because there have been some camera operators who seem to be there seem to be some camera operators out there who are trying to speed run cameras getting banned from all courtrooms. It's like, do you not like cameras in courtrooms? Because this is a pretty good way to go about it, journalists, because of your massive irresponsibility. So I'm sad to some degree we have to spell this out, but yeah, don't do that bullshit. That's some stuff, man, right? Yeah. Media requests for inspection or copies of trial exhibits shall be made on a form or in a manner prescribed by the clerk. The clerk's office shall make reasonable efforts to accommodate such requests in a timely manner, subject to court operation. Original trial exhibits shall remain in the custody or control of the clerk. I mean, also completely fair. So if there is an exhibit or that you want to use, then, send a request and the clerk will try to get to you as much as they can. Now, they're probably going to be pretty busy during the day, with being the clerk and all, but they'll try to get to you in a reasonable time frame. The reasonable time frame might not be till the next day, but live. Live. It's like you want to see the exhibit, you can. It's going to take a little time. So no problem with that. I have no problem with any of that. So far, so good. I have no problem really with any of this. I mean, the biggest thing you could have a problem with is the no live tweeting thing. I mean, it's the only thing you could really have a quibble about, but otherwise, so far, so good. I have no problem with any of this. All right, pressing on. Rule number 7, in accordance with Rule 119, the court prohibits filming or photograph of any juror or prospective juror. Again, really, do we need to say this out loud? But apparently we do. I'm looking at you like Court TV. You've done this before. It was an accident, I swear. Including during court proceedings and any court-conducted view. No person shall contact, follow, interview, or communicate in any way with a juror prior to the discharge of a jury or otherwise harass or tamper with a juror. Again, why do we need to say this out loud? We're into the why do I have to say this out loud section of the thing. Yeah, once the juror is sworn in, amazingly enough, yeah, you can't hey, juror number 7, it's day 5 of the trial. How do you think it's going so far? Right? That'd be really dumb. So yeah, amazingly enough, not so much with, contacting them, following them, interviewing them, harassing them, or really bothering them in any way. You're there to observe. So do that. Observe. Jeez. Come on, people. Juror impalement shall commence on April the 1st, 2025, which is still the most appropriate date for this ever, at 9:30 in the morning in the first session courtroom in Norfolk Superior Court. The court will permit a single pool film camera and single pool still camera for the first portion of impaling process, placing the defendant at bar, introducing the case, and preliminary instructions to the jury. The camera shall be focused only on the judge, clerk, defendant, and attorneys, and shall not film or photograph any prospective juror. Again, why do we need to say that last part out loud? I don't know, but apparently we do. We need to say that part out. When the court recesses after introduction of all of the case, all cameras shall be turned off for the remainder of the impanelment process. Media representatives, journalists, and public at large may observe, but shall not record or broadcast the subsequent individual voir dire. No cameras or recording devices shall be permitted on subsequent days of impalement. Also, nothing particularly unusual there. So we're not going to have streaming of the process during which they are going to ask the jurors their individual questions. And also no live tweeting from the courtroom relating to that. Not unprecedented, and I'm not necessarily even sure it's a bad idea. So you want to come in when, you know, we're doing the initial impanelment, like, you know, bringing them in and providing the initial instructions, that's cool. But, you know, for the individual Q&A, no, you can't be there for that. I mean, the public is still welcome to attend. It's still open to the public. Media is still allowed to be there. Just, you know, you're not allowed to broadcast that portion. So, you know, okay. I don't have any particular problem with that anyway. Saves me a couple days of streaming. So that's nice. Saves me a couple days of streaming of voir dire. So I'm fine with that. Impanelment? Impanelment. That's the right word. Yeah, impanelment. That's the right word. All persons subject to this order, including all media representatives, reporters, and journalists, are prohibited from interviewing or attempting to interview any person in the courtroom or courthouse. No person shall interview with intent to relay, transmit, or distribute publicly the contents of that interview. So if you do interview, anyone can use it. No copyright claim for you. Works for me. And any person in the courtroom or courthouse. The court prohibits any person from taking photographs, filming, recording, or broadcasting events occurring outside the courtroom in other areas of the courthouse. Okay. I mean, you know, again, fair. Completely fair, right? So again, if we needed to say it out loud, cameras, you can't shoot in the hallways. You can't shoot in the hallways. You can't shoot inside the courthouse. You can't shoot other exciting things happening in the courthouse. You can't conduct interviews inside the courthouse. At least that's the way I read the rule. I mean, the way the rule is written, I mean, it could be read more broadly than it's read. Like prohibiting interviews of any person in the courthouse. I mean, one way of reading that would be read to imply that if they're in the courthouse at all, you can't interview them. I don't think that's the right reading. The intended reading, I'm sure, is you can't interview them while they're in the courthouse, which, you know, fair enough. Fair enough. Again, this is like a place of business, right? This is a place of business. The court is in business. Other things are happening in the courthouse. So, you know, we don't want you conducting interviews and taking photographs and doing random interviews inside the courthouse. Take it outside. I have no problem with that either. That's perfectly fine by me. Court officers or court personnel are authorized by this order to secure any area which they deem necessary or appropriate action to ensure proper operation of court proceedings and the well-being of personal privacy. Duh. A violation of any provision of this order may constitute contempt of court. Court officers may eject or exclude entry to any person believed to have violated the rule. Okay. I mean, again, I basically have no problem with any of this. I have no problem with any of this. So like the only points you could really get upset about are no live tweeting. Sorry. From the courtroom. No live tweeting. Sorry. And the only other thing you could get upset about is if you read the rule dealing with people in the courthouse to mean if they're in the courthouse at all, as opposed to just they happen to be in the courthouse at the time, which I'm sure isn't what the court meant. But it could be read that way, but I'm sure that's not what it meant. So I have no problem with this order. So something from the judge, I really have no problem with. So that's fine. I have no problem with that. And incidentally, by the way, I think at least part of the reason that they don't want people live tweeting is because we're not 100% sure what else you're doing with your phone, right? It's like, because we don't allow recording and stuff like that, and we don't allow that kind of stuff. So I think one of the reasons they're concerned about it is like, oh, they don't want, you know, oh, all I'm doing is tweeting, even though I'm secretly recording it, right? And it's like, no, you're not allowed to do that. So it's like, we just make it easier by saying that you can't like live tweet it, basically. And that makes sense. So I have no problem with any of this. This is fine. This is fine. I have no problem with this. So if you want to take some outrage, you're going to have to take it somewhere else today. So that's that. And thank you, Tony, very much for helping me to dig that up. That was very nice of you. Yeah, that's completely acceptable. That's perfectly fine. She didn't kick the media out of the courtroom. She just basically said normal procedures, right? And no filming the jurors. Yeah. That was a great case. What was the name of that case? It was Shepard. Yeah, U.S. Supreme Court, Shepard, 1960s. A doctor on trial for killing his wife. Shepard v. Maxwell, I think was the name of the case. I think 1968. Shepard was on trial for killing his wife. He was a doctor. It was said to be the inspiration for the movie and the television show The Fugitive, although the people involved in The Fugitive denied it. But it's a similar case. It's a similar case in a lot of ways. Shepard was on trial for killing his wife. And the genius media at the time, just to show you like how great the media is, the genius media at the time decided in their infinite wisdom what they were going to do was they were going to publish pictures of the jury while the case was ongoing with their biographical and contact information, and they were going to publish it in the newspaper. Here's the jury. Here's their picture. Here's their name. Here's what they do. Here's where they live. Okay? And if that wasn't bad enough, the Shepard case was like the OJ of its time. It's a little bit forgotten these days for this aspect. But it was like the OJ or Johnny Depp or, pick your own case of point. It was a huge case. It was huge. And also, much like OJ, like everyone thought he was super duper guilty. Everyone thought he was super duper guilty. And the media was running articles about how they thought he was super duper guilty and then providing pictures, names, addresses, contact information of the jurors, right? Next to the sections about how he's super duper guilty. He's so guilty. He obviously killed his wife. The U.S. Supreme Court had a bit of a problem with that one. The U.S. Supreme Court had a bit of a problem with that one. And they're like, yeah, that doesn't work for us. We think it's possible that maybe posting the photos of the jurors with their contact information next to the section saying how Shepard is totally super, super guilty might have provided some undue influence on the jurors. We think that might have been a problem. Plus, I believe his memory serves, the jurors was like they were followed as they were going places and they were basically stalked. It was a total shit show. So that just in case you think, no, the media never would, they totally would. And they totally did. So, yeah, that was Shepard, and that was a great case. That's fantastic. Yeah. Is she trying to stop interviews outside the courthouse? That's not the way I would read the rule. The way the rule is written could be read that way, but that's not how I would interpret the rule. I don't think that was her intent. I don't think she's trying to stop interviews, except as it relates to the jury. Yeah, even them. Don't interview them anywhere. Leave the jury alone. Okay? Leave the jury alone, people. All right? Please, for the love of God. Just leave the jury alone. All right? Damn. But except for them, you can have interviews outside the courthouse, Yeah. So that would be fine. What if the jury wants to talk? Not while they're on duty, they can't. They're not allowed to talk. They're not allowed to talk. Not while the case is ongoing. You have to wait till it's over. Then you can talk to the jury. Not before. Leave the jury alone. Leave the jury alone. Why are you reviewing the DA video? What video is that, right? Yeah. Don't be surprised if Brennan files a motion to have cameras pulled. I wouldn't be surprised by anything at this point. And I also wouldn't be surprised if it's granted. Do we have to leave the jury alone? Yes. Also, by the way, just kind of leave the witnesses alone is also probably a pretty good tip, all things considered. And it's I don't want you to wind up in a harassment charge. So probably all things considered, it'd probably be advisable, although not required, but it would be advisable to probably also leave the witnesses alone. But that's just me. Can Bev change the distance for outside the court? Yeah, within a reasonable limit, she can, certainly. Yeah, time, place, manner restriction. So, and we've seen cases like that before. It's not a problem. So if she says, as long as it's anything approaching reasonable, And reasonable, obviously, is going to be dictated by the nature of the circumstances. And this case is more of a circus than most. So her discretion, therefore, goes up quite a lot. So, if, she said, like, you have to go across the street, or, no one, on the same block as the courthouse, I mean, maybe, right? So if she said, no one on the sidewalks surrounding the courthouse, probably okay. So as long as it's anything approaching reasonable, she'll be fine. And that's time, place, manner restriction. So should be fine. And the rationale for it is pretty simple: to keep proceedings civil, help people with their ingress and egress to the courthouse. When the jury's deliberating, make sure they're not standing right outside the window, that kind of thing. Yeah, pretty simple. Pretty simple. What else? Hopefully this jury will be more logical than first jury. Because, I was like, I only saw part of that jury interview. And I'm like, shaking my head, man. Shaking my head big time. It's like Karen Reed was there. John O'Keefe was there. Therefore, Karen Reed did it. Okay. That's not really how that works. But apparently some members of the jury were convinced. I'll tell you what. They let people protest right outside where juries can hear if the protests are what the government wants. Maybe. That's possible. I can't speak to that. I can only speak to what is possible in terms of the rules. So the question was, can the judge change the zone? I'm like, yes, she can. And here's the boundaries of where she can do it. So I was like, here's what's possible. So would a judge not do that because they want the protests? Maybe. It's possible, but that's not what we're talking about right now. I'm not sure that this judge would want these protests. That would be weird, right? Yeah, this judge definitely wants these protests right outside the courthouse. That's definitely something that seems plausible. Yeah, correlation's not causation. Yeah, correlation's not causation. Yeah, big time. It's like the snowplow driver was also there. Remember? He said he didn't see a body when he drove up. Maybe he did it, right? The snowplow driver was there. Karen Reed was there. A snowplow driver was there. John O'Keefe was there. I didn't see a body. I created one, right? Maybe the snowplow driver did it. And he was there at the same time. Why not? Right? It's like, yeah, logic doesn't work. Logic doesn't seem to work with these people. Also, maybe someone else was there. Who knows? Right? It's not like we know everyone who's necessarily there. Maybe someone random was just running through the yard and decided to kill him for no particular reason. Who knows? It's like I need a little bit more than, they happen to be there at the same time for beyond reasonable doubt. And it's really disappointing because we spend all this verbiage on beyond reasonable doubt, in Massachusetts in particular, because they have this to a moral certainty language, which is like, it's a really strong instruction. It's like to a moral certainty. And I'm like, you have a moral certainty with John O'Keefe was there, Karen Reed was there, therefore Karen Reed did it. You have a moral certainty to that? It's like, maybe we need to have a discussion about your morals, man. What's the issue, right? Yeah, he was so sweet. The snowplow driver, maybe he just puts on a good front. Ooh, deep dive conspiracies. Maybe he just puts on a really good front. Maybe it was all a show. Maybe he's snowplow driver, stalker at night, and he just knows how to put on a really friendly demeanor during day. He's a night walker. Yeah. As long as we're speculating wildly, and based on absolutely nothing. Right. Lucky's a simple man. He has a disability. That's just what he wants you to think. Well, not that it needs to be said. I don't think he did it. If that much wasn't already readily apparent, I don't think he did it. I'm certainly not claiming he did. But some people don't seem to speak sarcasm for some reason, so I guess I have to spell this out now for some reason. I don't know. What else? We could try watching the rest of the jury interview. We could try watching the rest of it. I don't know if I want to, though. I feel like I got the gist. Is X broken? A little bit, yeah. A little bit. And again, ultimately at the end of the day, and this is sort of, I think, also what the jury seems to not appreciate. At the end of the day, I don't have to know who did it. That's not my job. It's not the jury's job. It is not the jury's job to figure out who done it. That's not their job. The jury's job is also not to figure out ultimately whether or not there's a conspiracy against Karen Read or whether she's been framed. Ultimately, that's not their job. They tell the jury the job in the instructions, and their job is clear. Their job is only to determine whether or not the state has proven each and every element of the charge beyond a reasonable doubt. That's it. That's your only job. That's it. Your job isn't to try to figure out who done it. Your job isn't to try to figure out whether or not Karen Read is framed. Your job is simply to figure out, beyond a reasonable doubt, did the state prove each and every element of the charge? Yes, guilty. No, not guilty. It's that simple. It's that simple. So it is not my obligation, nor is it the defense's obligation, nor is it the jury's obligation to tell you who killed John O'Keefe. That's not our job. Who killed John O'Keefe? Don't know. Maybe it was Karen Read. Maybe it was Karen Read. Not my job. My job is simply to figure out whether the state proved it beyond a reasonable doubt. That is my job. And for that, I look at the evidence and the solo cops and so forth and so on, and I'm like, hell no. Not even kind of, no, not just no, just all the no. All the no, you did not prove your case. And, maybe Karen Read did it. Maybe that means she gets away with murder. But, that's what's supposed to happen if they can't prove it beyond a reasonable doubt. And maybe that's the part that people have trouble with. It's like, you're letting her get away with murder. Maybe. But I'm supposed to. I'm supposed to let her get away with murder. That's what's supposed to occur if the state can't prove it beyond a reasonable doubt as to each and every element. And maybe that's the part people have trouble with, but that's the job. That's the job. So is she getting away with murder? Maybe. I don't know. Maybe. But if the state didn't prove it, that's it. End of analysis. Right? That's the game. So, plus, I also don't think it's particularly likely that Karen Read did it, with the physics and all. So, I thought the ARC experts were pretty credible. The jurors apparently were not so persuaded by the ARCA experts with their PhDs in physics. Apparently they were less persuaded by the physics. I was more persuaded by the physics, plus also a bit of common sense, to be quite honest. So I don't really think that Karen Read did it, but maybe she did. Maybe physics, maybe the PhD physics people are wrong. I mean, it could happen. PhDs have been wrong before. Could be. You know, could be it. They believe Jen McCabe. Yeah, I mean, again, credibility is a question for the jury. So I suppose you could believe Jen McCabe. Although, really, to be honest, even if you believe Jen McCabe, I'm not really sure it gets you to the end of the page. Because people, when they're excited, say all kinds of shit. You know this, and I know this. Have you ever been around a person who's kind of hysterical? I mean, yeah. I mean, I'm assuming this has happened in your life. And people who are, people who are hysterical kind of say all kinds of shit because they're hysterical. So, like, even if you assume she said, I did it. Like in her state where, she just, found her dead boyfriend dead, it's not exactly necessarily conducive to being particularly sober reflection. Sober, not necessarily referring to alcohol in this context. Sober referring to, less emotional in this context. So it's like, even if you assume Karen Reed said, I did it. It's like, there's no particular reason to believe that that's necessarily a confession because she could have just been hysterical, which would have been pretty reasonable. And there's lots of testimony relating to her state at the time. There's lots of testimony relating to her state. And generally speaking, people seem to describe her as hysterical, which seems pretty reasonable to me. So it's like, I don't know that you necessarily take the even if you believe Jen McCabe, which is one hell of a thing, because I didn't find her particularly credible. But even if you believe Jen McCabe, that she said it, it's like, well, other testimony said that she was hysterical at the time. It's like, so, what is the probative value of that statement is, somewhat diminished to my mind. Now, that being the case, however, confessions are, of course, the state's favorite thing. And it is unfortunately true, and it's extremely true, that a confession pretty much dooms you, because people seem to think, for some reason, and I don't know why they think this, but people seem to think for some reason that, if I didn't do it, I'd never confess. When, right, basically, like, there's lots of information to the contrary on that. The Innocence Project will be happy to tell you about lots of cases to the contrary. And, we know false confessions happen. They happen even in police interrogation rooms when people are a bit more sober comparatively. It's like, so, but people don't seem to think this for some reason. They're like, if I would never say I did it, if I hadn't done it, I would never say I did it. It must be she said it because she did it. It doesn't matter how hysterical I am. I would never say such a thing. People seem to think this for some reason. I don't know why they think it, but they seem to think it for some reason. It's like only a guilty person would say they did it. It's like, really? It's like, do you not know much about human nature? Or like, if you've never met a person who said something that they didn't believe, or said something that was a lie, or said something even self-incriminating, that you never met anyone who has done that to you. You've never met anyone who said anything, like, even though they're just because they're kind of a little bit out of it, and they've never said anything that like kind of makes them look bad, even though it's not really true. But juries eat up confessions. They eat them up. They eat them up every single time. And the confession is like, it pretty much always dooms you. And it doesn't really matter how much the defense has on their side. Confessions are the thing. So it's like, so if you believe Jen McCabe that Karen Reed said, I did it. The unfortunate reality is, if you believe that, most juries are going to convict. Because most juries seem to be under this opinion that no person would ever say it falsely. And that's just the reality. That's just the reality. So from that point of view, it doesn't make a lot. It's a lot more plausible that the jury is ready to convict because she said she did it. It must be true. It's depressing, but true. Can Bev claim a statement made by AJ she finds out of order can be included in first decisions regarding statements? I don't understand your question. Yeah, false confessions are definitely a thing. I bet you most police officers could tell you a story from their career. Ask your friendly neighborhood police officer if they've ever personally, in their own career, seen a false confession. I bet you a lot of, particularly if they're a detective. I bet you a lot have. Well, I'll take a bet on that one. What else? Yeah, there's so many cases where false confessions. Yeah, it's unfortunately it's unfortunately very much a thing. It's one of the reasons that lawyers tell you not to talk to the police, because it's actually really hard. And no, you're not talented enough. You can't do it. So don't delude yourself. You're not good enough. I'm not good enough. No one is good enough. But it's actually really hard to not make some statement that will incriminate you in some respect. Not the least of reasons for you don't necessarily know what the police are looking for. So you don't necessarily even know what could be incriminating because you don't necessarily know what they're looking for. It's actually really, really difficult. It's actually kind of impossible, to be honest. It's basically impossible to do it. You basically can't do it. They can't make some statement that won't incriminate you. Yeah, like that won't happen. Have you been talking to the police for like more than 30 seconds? Like then, you probably said something that will incriminate you to some degree. Right? I mean, this is why we tell you not to talk to police, because it just won't go well. You are not smart enough. You are not smart enough. You are not wise enough. You are not clever enough. No one is smart enough, clever enough, or wise enough. No one can do it. You're doomed. Listen to the nice lawyer and invoke your right to remain silent. I want to remain silent. I want a lawyer. That is what you say. I want a lawyer. I want to remain silent. You say that and repeat as required. You don't say anything else. Just say those things. Say nothing else. You'll be a much happier person. Yeah. Yeah, police unions tell their members not to talk to the police. Yeah, you better believe it, right? Yeah. It's like the police unions tell the police not to talk to the police. Police will tell you not to talk to the police if they're not the ones talking to you. Yeah. 100%. Kurt, if the defense makes a comment in the appeal that AmpBev believes taints the jury, can she fine them under this order? No. And there are no appeals right now, and the federal court proceedings are already filed anyway. So I'm not even sure hypothetically what that would be. I'm not even sure hypothetically what that would be at this point. In body cam vids, when the cops arrest another cop, they always whisper not to say anything. You know it, baby. 100%. It's good advice. You should take it too. You should take it too. He's talking about the footnote made about AJ. Okay, what footnote? What footnote? The only footnote I see is a footnote to Dabur. Kurt, if the court, if he says something she admonished him for, in court, if he says something she admonished him for as an extrajudicial statement she warned him about, well, if to the extent that it should be under seal, maybe. I mean, yes. In the future, that's what the order seems to contemplate. The order seems to contemplate that if in the future he makes a statement in open court that would prejudice the jury, then he should make it in a sealed proceeding. That seems to be what the order contemplates, at least in part. How are they able to find jurors who don't know about the case? I don't know that's necessarily as hard as you'd necessarily anticipate it to be. I'd be interested to know how many people live in this district. So this is like Norfolk, Superior. Yeah, because how many people live in this district? I'm going to assume it's fairly populated. So I don't necessarily think it's going to be as hard as you might anticipate. People have a lot of things going on in their lives. And these days in particular, there's a lot of news, man, from a lot of sources. Social media is always full all the time with all kinds of stuff. The news is talking about lots of things all the time. Some people don't even watch the news. A lot of people don't watch the news. So I don't think it necessarily will be as difficult as you might anticipate to find people who haven't heard about this particular case, especially if there's a lot of people in the jurisdiction. So it depends on the population, but if there's a sizable population, Superior Court. Okay, yeah, Norfolk Superior Court. It's in Dedham, Massachusetts. So what is their jurisdiction, like the county? It'd be nice if I got like a map of their jurisdiction. See if it's on their webpage. And not really. Let's just assume it's the county though that they're in. Okay. All right. And so this is Norfolk County. Norfolk County population 725,000. Yeah. So assuming that 725,000, I wouldn't think it would be as difficult to find a jury as you might anticipate it to be. It's big news, but it's big news, especially big news for the locality. But I don't. It wouldn't surprise me that a lot of people have not necessarily heard about it or haven't paid attention to it. And by the way, the standard, of course, isn't that you haven't heard about it. The standard is that you weren't be biased of it. So that they might have heard a mention of it or two, or whatever as part of their life. I don't think it would be as difficult as you might anticipate. So I think it's doable. I think it's doable. Yeah, 725,000 people is a fair amount of people, man. Yeah, 530,000 registered voters. Yeah, 500,000 people is a fair amount of people. I think it's doable. How can we go about getting judicial reform in federal, state, and district courts? Talk to the legislature. Petition your member of Congress. That would be the best way to go about doing that. Yeah. Like this is a lot different than Koberger, because in Koberger, right, in Moscow, where he was when I said this exact issue, it was like in Moscow, Idaho. Right? Moscow, Idaho was in, or still is for that matter, in Latah County, Idaho, which had a population of 39,500. Right? And it's like, well, and it's actually worse than that, because a lot of them are college students or college related, right? Professors and stuff like that. It's a town of 40,000. And it's like, yeah, that's a bigger problem. So it's like, oh yeah, when they were discussing moving the case out of Moscow, Idaho, when they're discussing moving Latah, it's like, yeah, they're going to grant that change of venue, because like there's no way you're going to find an unbiased jury in a population of 40,000, particularly when it's a college town. Like the college is the town, man. Right? The college is the town. Like all the people that live there are at the college or closely related to the college. They're all the college, man. Damn, they're all the college, right? So it's like, okay, yeah. I mean, you're never going to find an unbiased jury there. They've all heard about this case, right? They've all heard about this case. It was a quadruple college murder. Okay, I think we can appreciate the town of 40,000 might have been talking about the quadruple college murder in the college town. So I was like, yeah, you'll never find a jury of 12 in that. And unsurprisingly enough, yeah, that they transferred venue out of that to Atty County, where some other people live. So it's like, yeah, I was not completely not surprised by that change of venue, because it's like you'll never find a fair jury in Moscow, Idaho. How is that going to happen for the quadruple murder? Not going to happen, right? So it's like, yeah, they transferred that venue. This is not quite that situation. We have a little bit more to work with. We have a little bit more to work with. Yeah. All right, guys. I guess I'm going to sign off for now. And I've appreciated our time spent together. And by the way, if you wouldn't mind throwing me a couple bucks, I would appreciate it. I'm having to pay for my weight loss medication, which is quite expensive, and also would like to keep the lights on and stuff like that. So if you wouldn't mind throwing a buck in the 10, I'd appreciate it. And also don't forget to hit that join button. For only 99 cents a month, you too can become an uncivilian and help grow the channel. I do see some names in gray in the channel. I can't help noticing there's quite a few names in gray today in the channel, but you can fix that problem. So by hitting the join button today, you become a member of the channel. You get some behind the scenes content, you get off stream content, you get cooking streams, you get some other stuff, all kinds of stuff. And it's only $1. It is $1. I literally can't make it any cheaper, man. It's $1. Snacks for gives $19.99 in pounds. Thank you very much, Snacks. I do appreciate it. $1 a month, man. What can you buy for $1 a month? Not much. But you can buy just a little bit of my love. That's a pretty good deal, man. That's what I'm saying. Thank you, Mary, for $10. I do appreciate it. It is appreciated. You get some cool icons. You get some emojis, behind the scenes content. It's nice. All right, guys, I'm going to go ahead and sign off until later. And by the way, of course, join me on my Discord, which I'm sure Tony will be putting in the comment section. You can join me on my Discord if you give me story suggestions, where if the court drops more documents, it's a great way to bring things to my attention, is to put it on Discord. So if you see the court drops new things or whatever, or there's other stories you want covered, my Discord is the best place to do that. So go ahead and do that there. And thank you, Glow T, for $4.99. I do appreciate it. Until later, I've been Uncivil Law. Talk to you later, my friends. Clear, bye, and have a great one. Bye-bye.